Welcome back to the Constitutional Clarion. This is another video in response to a viewer request. The question was about what power the Australian military, known in Australia as the Australian Defence Force or the ADF, has in relation to a civil emergency that doesn't concern defence, such as a natural disaster or a pandemic. The short answer is not a lot. In this video, I'll explain the constitutional powers that apply in relation to the ADF and the difficulties that arise in deploying the ADF to deal with non-defence emergencies, which is often described in military language as giving aid to the civil power. The most important constitutional power concerning the ADF is section 51(6) of the Commonwealth Constitution. It gives the Commonwealth Parliament power to make laws with respect to the naval and military defence of the Commonwealth and the several states, and the control of the forces to execute and maintain the laws of the Commonwealth. It's a purposive power, meaning that any law made under it must be made for the purpose of the defence of Australia. The scope of this power waxes and wanes, so that means it expands and it contracts. During a time of peace, it authorises making laws that have as their direct object the defence of Australia. Now, this can include the recruitment, enlistment and training of the armed forces, their equipment, weapons and munitions, the erection of fortifications, etc. So those things that deal directly with defence per se. But during war, and in the period where you're preparing for war and winding down from war conditions, this power is treated as being much broader. According to Justice Fulliger in the Communist Party case in 1951, it extends to an infinite variety of matters which could not be regarded in the normal conditions of national life as having any connection with defence, such as prices of goods and their rationing, rents, the transfer of interests in land and industrial employment. A court will ask whether the law is reasonably capable of being viewed as appropriate and adapted to the defence of Australia. It's not for the court to decide whether the law is good or bad or will be effective in achieving Australia's defence or not. During times of war, courts also tend to give deference to the legislature and the executive and their judgment because the courts may not be aware of all the relevant defence considerations. In addition, Section 114 of the Constitution provides that the Australian states may not, without the consent of the Commonwealth Parliament, raise or maintain any naval or military force. They may have their own police forces, but not military. Now, the quid pro quo for that is in section 119, which provides that the Commonwealth shall protect every state against invasion and, on the application of the executive government of the state, against domestic violence. Now, domestic violence here doesn't mean family violence in the way we normally use it. It means forms of internal violence within the state that are directed at or actually threaten the state, such as things like riots or terrorism. So the Commonwealth can confer powers on the ADF to deal not only with the defence of Australia from external threats, but also the protection of a state upon its request from domestic violence, which is an internal threat, such as terrorism. Such an exercise of legislative power would be incidental to the execution of section 119 of the Constitution, and therefore it falls within Commonwealth legislative power. What if a state, however, does not make a request for that protection? Justice Dixon, in a case called the Crown against Sharkey from 1949, said that where domestic violence within a state interferes with the operations of the Commonwealth government, the Commonwealth may, quote, without a summons from the state, interfere to restore order, unquote. The Commonwealth may therefore act to protect the postal system or the rights of electors to be able to vote in federal elections, because it should not be dependent upon a request from the states to be able to protect the effective exercise of its own powers or the operation of its own laws. Another example is the protection of foreign dignitaries, such as after the Hilton bombing in Sydney in 1978, when visiting heads of state were here for a regional chogger meeting. The troops could be deployed, and indeed were deployed in that case, to protect those visiting heads of state. The High Courts also held, in a case called Thomas and Mowbray from 2007, that the defence power supports laws with respect to terrorism generally, including the imposition of control orders on people. The Commonwealth Parliament enacted the Defence Act 1903 to set down the rules for the deployment of the ADF. In addition to using the ADF for Australia's defence, which of course is its core purpose, Part 3 AAA deals with protection against domestic violence. It permits the Governor-General to issue a call-out order on the advice of authorising ministers. The order can be a contingent order or an immediate one. The purpose of the order may be to protect Commonwealth interests or to protect a state or self-governing territory from domestic violence. In all cases, however, there must be domestic violence or the threat or risk of it to justify the call-out. If called out under these provisions, the ADF may be authorised to exercise coercive powers. For example, the Minister may authorise a member of the ADF acting under Part 3 AAA to exercise the power to search people and locations, seize things, control the movement of persons, detain persons, provide security by patrolling or securing areas, and direct persons to answer questions or to operate equipment. But what about the use of the ADF to deal with emergencies that do not involve violence? In January 2020, the Commonwealth deployed the ADF to provide aid during the bushfire crisis in Eastern Australia. This could not be done under the statutory provisions in Part 3 AAA of the Defence Act 1903 because no defence or domestic violence was involved. There was also a call-out of the ADF reserves, and this was done under Section 28 of the Defence Act to, quote, provide civil aid, humanitarian assistance, medical or civil emergency or disaster relief, unquote. But this itself does not authorise coercive action, and it's also, I have to say, rather unclear what the constitutional basis of that section is. Members of the ADF can, of course, perform acts that are not unlawful in the same way as other people can. So this means that during a bushfire, they can provide ships and vehicles to rescue people who are at risk. They can extinguish fires or remove debris that's blocking roads or provide logistics and coordination. And they can use special equipment and skills that they have, such as building temporary bridges across rivers. So there are many things that the ADF can do during an emergency that don't involve the exercise of coercive powers. In March 2020, members of the ADF were deployed during the COVID-19 pandemic, engaging in activities including contact tracing, restricting or preventing movement across state borders, logistics, and checking compliance with isolation orders. In both cases, the deployment, apart from that exception in relation to the call-out of the reserves, relied upon non-statutory executive power. Now, this is sometimes described as an implied nationhood power or a prerogative power. The nationhood power has been described in the AAP case from 1975 as encompassing, quote, the capacity to engage in enterprises and activities peculiarly adapted to the government of a nation which cannot otherwise be carried on for the benefit of the nation. If one tries to translate that to emergencies, it suggests that the nature of the emergency or the capacity to deal with it must be peculiarly national in nature and outside the capacity of the states to manage. In addition, the Commonwealth's prerogative powers, which are old, inherited executive powers, include a power of self-protection, which is necessary to preserve the existence of the Commonwealth and the proper exercise of its powers. There may also be a prerogative power to deal with emergencies, but the authority on that remains rather old and unclear. Because there was no statutory basis for the deployment of the ADF to deal with civil emergencies such as the bushfires and the COVID-19 pandemic, there was no legislative authority for them to use coercive powers. This was accepted by the Minister for Defence in relation to the ADF's COVID-19 role. The Minister stated in a media release on the 29th of March 2020 that no coercive powers had been conferred on the ADF. And this was the case even though the functions allocated to ADF members included manning roadblocks on state borders and aiding in the enforcement of lockdowns, both of which involve giving effect to restrictions on freedom of movement, which would seem coercive in nature. It appears that reliance was placed upon the local police to actually do the enforcement of the state laws, while the ADF personnel provided the visual and psychological impression of there being additional force by simply being there in uniform. Obviously, they still fulfilled their other non-coercive functions that assisted the functions of the police. The Department of Defence announced on the 11th of July 2020 that, quote, the ADF will not be authorised as law enforcement officers as this remains the responsibility of the states and the territories, unquote. In a submission to a parliamentary committee, the Department of Defence explained in 2020 the legal position as follows, quote, deploying the ADF to assist civil authorities and the community may be characterised as part of the nationhood power, although there has never been any jurisprudence to confirm this. Assistance to the civil community in situations that do not reach the legislative threshold for domestic violence is likely to be confined in the following ways. A, the non-statutory executive power would not authorise the use of force beyond what is available to members of the community generally, for example, self-defence. And B, the non-statutory executive power would not generally authorise the use of coercive powers, for example, powers to control people's movement or detain people, unquote. So you can see from that submission that the Department of Defence was very conscious of the legal and constitutional restrictions on the powers of the ADF when being deployed during a pandemic, and that they had no coercive powers beyond the powers that any ordinary person can exercise. Given that the ADF is exercising non-statutory executive powers, you'd think there must be some kind of document that they use to regulate the exercise of those powers, and there is. So it's called the Defence Assistance to the Civil Community Manual, so the DAC manual. At the time of COVID-19, and I specify that because I haven't checked the updated DAC manual, but for present purposes, seeing we're talking about COVID-19, it's relevant what it said then. And it said then that only those activities where use of force or potential use of force, including intrusive or coercive acts, is not involved, only those activities are authorised under this manual. It also said that state and territory governments have primary responsibility for the protection of life, property and the environment, including emergency responses, and that they may only seek ADF assistance where, quote, the scale of the emergency or disaster exceeds or exhausts the response capacity and capabilities of the state or territory, or where resources cannot be mobilised in sufficient time, unquote. All of this led to concerns that the ADF personnel were unprotected from people taking legal action against them for acting as directed under the chain of command during a civil emergency. The Commonwealth Parliament therefore enacted the Defence Legislation Amendment Enforcement of Defence Force Response to Emergencies Act 2020. It inserted section 123, capital A, in the Defence Act. It tried to attract the support of the nationhood power by tying the immunity granted to ADF members to the nature of an emergency. That is, that the emergency is one that is peculiarly national in nature and outside the capacity of the states to manage. But it does this in a rather peculiar roundabout way. Members of the ADF gain an immunity in relation to acts that are done in good faith in the performance of duties where they are providing assistance to prepare for or in response to a natural disaster or other emergency, and the assistance is provided at the direction of the minister. Now, the minister may only make such a direction if satisfied that either A, the nature or scale of the natural disaster or other emergency makes it necessary for the benefit of the nation, for the Commonwealth, through the use of the ADF's or the department's special capabilities or available resources to provide the assistance, or B, the assistance is necessary for the protection of Commonwealth agencies, Commonwealth personnel, or Commonwealth property. As you can see from this outline, there remains a lot of uncertainty about the deployment of the ADF to deal with emergencies. It's fine when all they are doing is helping people, such as providing logistical support or communications, or physical help in removing debris and cleaning up after floods. Problems only arise where they are taking actions like restricting the movement of people or detaining them or otherwise exercising coercive power. This is because there's no clear constitutional power to support legislation that would authorise the use of coercion, and the non-statutory executive powers, such as the prerogative and the nationhood power, probably do not support coercion. Now, the reason for the word probably there is that we don't have a lot of clear authority on the subject. So a fair bit of guessing and drawing of analogies from old cases is required to provide any advice on this subject. The answers just aren't clear. Now, finally, a word of caution. Don't go defying members of the armed forces during an emergency just because the constitutional clarion told you they have no coercive powers. Because it's always possible that there are other laws that support their actions in particular cases. They may be exercising powers under a state law or under a Commonwealth law that's supported by another head of power, such as the quarantine power. For example, there are provisions in the Biosecurity Act which permit ADF members, if appropriately qualified, to be biosecurity officers or human biosecurity officers who can exercise various coercive powers. The law is a complex thing. There are lots of different laws, so don't assume that you now know everything just from watching a video, even one of mine. Now, with that warning, thank you again for watching the Constitutional Clarion. I hope you found this explanation enlightening, and as always, I look forward to seeing you next time. Goodbye.